all the... Hello, am I audible to everyone?
Yes, ma'am.
Okay, thank you, sir. Thank you very much. Sir, respected Advocate Shri Bajpayee sir has also joined, and Dr. Poonam Nathani madam, she has also joined the meeting, and teachers and students are there. So I think with the permission of our sir, we will start with the meeting today. I'm very happy to welcome Advocate Shri Bajpayee sir this meeting. I also welcome Principal Dr. Poonam Nathani madam, all the teachers who are present here, and all the participants of this lecture series, and all my dear students. A very warm welcome to everyone. And today's lecture series we are having on the topic of appointment of judges to the higher judiciary, a never-ending controversy. A very important topic from the point of view of the law graduates and the members of the law fraternity. And I really thank Advocate Shri Shetty sir, who is a resource person today, and he'll be speaking on this particular topic. He will having a discussion on this topic. So I welcome you also, sir. And I thank you for choosing this important, crucial topic for the students for today's lecture series. So I would like to give the charge to Advocate Shri Shetty sir now to start with the meeting.
Thank you, ma'am. I hope I'm properly audible to you all.
I'll just take a minute. Yes, the recording is started. Yes, so I welcome you, sir, and I give the charge to you to start with the lecture. Thank you.
Thank you, ma'am. I hope I'm properly audible.
Yes, sir. You're audible, and even the slide is also visible to us.
Yes, thank you, ma'am. Respected Ashiji Bajpayee sir, a mentor, guide, and the person who is instrumental in starting this lecture series. Our dynamic leader, Dr. Poonam Nathani madam, principal in charge. Today's coordinator of our lecture series, Dr. Panchal madam. My dear colleagues, esteemed colleagues from the teaching faculty, as well as my dear students. A warm good evening to you all, as well as welcome to this session of lecture. Today's topic for discussion is appointment of judges to the higher judiciary, a never-ending controversy. Now, a question might come to your mind, what is a never-ending controversy? When you say never-ending controversy, it is the tug of war between the judiciary and the executive. Before we proceed with the facts and circumstances of such controversy, we will discuss some points for the better understanding of this topic. Now, under the doctrine of separation of powers, the organs of the government have been divided into three main organs, that is legislature, executive, and judiciary. And when we discuss about these three organs, Constitution has provided for separation of powers, where legislators make laws, executive carries out our laws or implements the laws, and judiciary, their main activity is to interpret the laws as well as apply the laws to the facts in administration of justice. Now, today's topic is mainly on judiciary. When we say judiciary, let us understand what is meant by judiciary. This is the important organ of the country's government and a democracy, and it is responsible for its legal system, and which consists of all the judges in the country's court of law. That means all the judges in the entire hierarchy of the court comes under the definition of judiciary. We need a judiciary that protects the right of all our citizens. That is why we need an independent judiciary. When we say independent judiciary, the decision cannot be decision of any court, even if the lowest court to the apex court. the decision cannot be influenced by any outside influence, which means nobody can influence the decision of the judiciary, and the decision
Alter.
arrived solely on the basis of rule of law. Somebody has unmuted the mic and disturbing the lecture. I
Yes, I'm
request all of
muted.
the
Yes, I'm
students to mute your mics. Well,
yes,
continuing with the lecture, we must understand the hierarchy of the courts. This is what you see on your screen is the Supreme Court of India. As far as territorial jurisdiction of the Supreme Court of India, it's the apex court of India, and the territorial jurisdiction covers the entire country. We see here some of the high courts. Total as of today, we have 25 high courts. These are the pictures of Calcutta High Court, Madras High Court, Allahabad High Court, Delhi High Court, and High Court of Bombay and Goa, which is applicable to Maharashtra and Goa. Now, these are the subordinate courts: Chief Metropolitan Magistrate, District Court of Latur, also we can see, Small Causes Court of Mumbai. All these are lower courts. Now, we will not be covering these lower courts. We will be, during today's lecture, today's discussion, we'll be covering only higher judiciary. When we say higher judiciary, it is Supreme Court and the High Courts of India. So it is the apex court of the country, as far as Supreme Court is concerned. It is the apex court of the country and was constituted on 28th January of 1950. It is the highest court of appeal and enjoys both original suits and appeals of High Court judgments. So it has original jurisdictions as well as appellate jurisdiction, then supervisory, advisory jurisdiction. There are many, being apex court of the country, it has many jurisdictions. The Supreme Court of India has been constituted and established as per Article 124 of the Constitution. Now the newly sanctioned strength is total 34 judges. Initially, the sanctioned strength is 7 judges. Presently, after the retirement of the Chief Justice of India, Dhananjay Chandrachud, sir, we have 2 vacancies in the Supreme Court. The appointment of the judges is made as per the provisions of Article 124, Clause 2. Now, these are the basic information we must understand before proceeding with the various aspects of appointment of judges. Now, as far as High Court is concerned, Article 214 of the Constitution provides for high courts at various state capitals. But as far as the provisions of Article 231, a high court can be established for 2 or more states. Just for example, Bombay High Court covers 2 states, that is Maharashtra and Goa. So there's a common high court for these 2 states. This provision is made under Article 231 to have a common high court for 2 or more states, or maybe a union territory. Article 217 provides for the procedure for appointment of judges to the High Court, and there is no maximum limit of judges to the High Court. Now, this is one of the essential factors we must understand, the Supreme Court Collegium, because the Collegium has been given the authority to appoint judges. This is the present Supreme Court Collegium, Chief Justice of India, Justice Sanjeev Khanna, as 4 senior most judges, Justice Bhushan Gavai, Justice Suryakant, Justice Rishikesh Roy, and Justice Abhay S. Oka. That means the collegium consists of Chief Justice of India plus 4 senior most judges. This is usually the composition. There was one incident where the collegium had 6 members. That was during Justice CJ, Chief Justice of India, Dhananjay Chandrachud's tenure, because the 3rd judge's case says that the collegium must also consist the next in line Chief Justice of India. So during that period, after CJ Chandrachud, there were 4 senior most judges who were not in next in line. So Sanjeev Khanna was also included in the collegium. So at that time, it had 6 members. Now, today's topic of discussion, appointment of judges to the higher judiciary, a never-ending controversy. is an important subject matter affecting each and every person of India, each and every citizen of India. Now, when I say it is an important subject affecting each and every person of India, some of you who are present here may not agree with me. How does it concern us? I do not have a case pending before the court. I have not filed a petition. How it is going to affect me if a particular judge is appointed or someone else is appointed? Now, I, according to my opinion, this is a wrong assumption. And to prove my point, I will discuss three landmark judges here. And all these three judgments have far-reaching consequences, not only during the judgment was pronounced, even today and in the coming time also. This will have far-reaching consequences. The first case I'm going to discuss is the Keswanand Bharti case. Keswanand Bharti was the state of Kerala. A judgment pronounced by the apex court, the Honorable Supreme Court, in the year 1973, which is also known as fundamental case, or shortly it is known as Keswanand Bharti judgment, which established the doctrine of basic structure of Indian Constitution. Now, what happened in this case was Article 368 of the Constitution provides for amendment of the Constitution. A law cannot be static. It cannot be rigid. It has to be changed. It has to be amended according to the situation of the prevailing situation, so that provisions of the laws can be used during the present situation. But some of the political parties, over-ambitious political parties, try to uh, uh, remove some of the fundamental rights, and they wanted to curtail certain rights. Now, in this judgment, which was given by 13-judge bench, the ultimate judgment was 7:6. Now, it is the wisdom, vision, and the judicial activism of these great judges which made it possible to retain the fundamental rights which are available as of today. Now, some of you may not have been even born during that period of judgment, but still we reap the decision, the fruits of that decision, because if fundamental rights are available to us as of today, that is because of this important landmark judgment, Keshwanand Bharti's case. Now, this ruling affirmed the supremacy of the Constitution, the independence of the judiciary, and the rule of law. And today we are enjoying the fruits. Secondly, Maneka Gandhi's case, Maneka Gandhi versus Union of India, was a landmark judgment of the Honorable Supreme Court, pronounced in the year 1978, that expanded the meaning of Article 21 of the Constitution, which provides the fundamental right to life and liberty. Now, in this case, the meaning of the right to life and liberty was widely interpreted. And for the first time, procedure established by law is interpreted to mean due process. Mind you, this word is not used in our Constitution in Article 21, um, whereas this word of due process is used in the American Constitution. Um, while framing the Constitution, this word was under discussion, but was not used for different various reasons that we will not discuss here today. But for the first time, procedure established by law was interpreted to mean due process, and because of that, due process means just, fair, and reasonable. And because of such wide interpretation, later on, Article 21 was lying idle till then, till the decision of Maneka Gandhi and Maneka Gandhi versus Union of India. But after the judgment, it became active. Article 21 became active, and various subjects like dignity, livelihood, privacy, clean environment, health, education, etc., were included in the meaning of right to life. Thirdly, public interest litigation. There are many public interest litigation. One of the public spirited person, MC Mehta, has filed many public interest litigation. Now, this public interest litigation is not provided anywhere, not even in the Constitution, not in any of the laws. This is born out of judicial activism to give effect to the assurance given to the public by the preamble of the Constitution of India, that to secure all its citizens justice in all aspects. Now, some of the section of the society are deprived to have access to justice because of their economical condition. Maybe they are not aware of their rights and the platforms where to approach to enforce such rights. Now, what this great great judges thought, if these people cannot approach us, why not we should reach them out? So they developed this concept of public interest litigation only through their wisdom and vision and the vision of making law, which is enacted for the welfare of the society, that we will actually make uh, use of these laws to make welfare of the society. So the pioneers of this public interest litigation are Justice V.R. Krishnaiah and Justice P.N. Bhagwati. Um, they have also included the epistolary jurisdiction. If you remember Sunil Batra's case, a simple letter, a simple postcard was converted into a petition. Now this is done. Law does not provide this for this, but this is provided by the public spirited judges only to provide relief and remedy with justice. So through this discussion, we understand that who occupies the office of the judges is very, very important in our life, and their decisions, all through these decisions, how it is going to affect our lives is important. That is why my contention is that the appointment of judges is very essential. Every person is a stakeholder in the appointment of judges. Now, today's discussion entirely revolves around three important doctrines. One is separation of powers, part of the basic structure; independence of judiciary, again part of the basic structure; and rule of law, again part of the basic structure. Now, let us start our discussion today with very oftenly repeated quote: "Power corrupts, and absolute power corrupts absolutely." And to do away with that, we have separation of powers. We have divided the functions of a democratic country into three organs, that is legislature, which enacts laws; executive implements and enforces laws; judiciary interprets and applies laws to protect the rights of the people, where every organ area of function is clearly defined and no one is expected to encroach into the territory of others. Now, as far as judiciary is concerned, a provision in Article 50, if you remember, requires the state to take necessary steps to separate the judiciary from executive. Now, this is also provision to separate executive from judiciary with Article 50. Uh, but one important point you have to consider here is it is a directive principles of state policy. So there is no enforceability. Maybe that is the reason why executive take advantage of this. This is very essential to promote the rule of law. Now we'll see just some of the provisions as far as appointment of judges to the Supreme Court. Article 124 clause 2, which provides that the president shall appoint the judges of the Supreme Court in consultation with the Chief Justice of India. I request all of you to pay attention to the word consultation. Now, appointment of judges to the High Court provisions, Article 217. The President shall appoint the Chief Justice of High Court after consultation with the CJI, Chief Justice of India, and Governor of the state, and while appointing the puisne judges, that is subordinate judges, he will also consult the Chief Justice of the High Court. Now, as far as, again, I request you to pay attention to the wordings, that is consultation with. Now, primacy is given to the executive. According to the provision, if you see, the primacy is given to the executive, that is the President of India. That is very clear. The provisions are very clear. Then the question arises in our mind, what is the controversy is about? When the law is very clear, as far as the appointment of judges is concerned, president has to consult with them. Now, mind you, the word consultation does not mean concurrence. President is not required to agree with the whatever names have been proposed by the judiciary or the CJI. Now we'll see what factors led to controversy. When you are discussing about the controversy as far as appointment of judges is concerned, what are the factors which lead to controversy? First factor is constitutional provisions. Article 74 provides that there shall be council of ministers headed by the prime minister to aid and advise the president in exercise of his functions. Now, if you pay close attention to the provision, what it says, uh, there shall be a council of ministers headed by the prime minister to aid and advise the president. That means prime minister and his cabinet council of ministers will be advising the principal, advising the president in whatever decision he is going to take. But there's no mention that, or there's nothing to suggest that such advice is binding on the president. As far as provisions of the Article 74 is concerned, there shall be prime minister and his cabinet ministers or the council of ministers to aid and advise the president. But the provision does not suggest that such advice is binding on the president. Now, very important to note that the 42nd constitutional amendment of 1976, which amends Article 74 to provide that president shall be bound by the advice of the council of ministers. Now here comes the change, important change. Earlier, there's nothing to suggest that the advice is binding on the president, but after 42nd constitutional amendment, now that advice is binding on the president. Now, in 44th Amendment to the Constitution 1978, inserted a proviso that provided that the president may require the council of ministers to reconsider such advice, either generally or otherwise, and the president shall act in accordance with the advice tendered after such reconsideration. Now that means, at the most, what the president can do, he can ask the prime minister and his council of ministers to reconsider whatever advice they have given to him. But after reconsideration, when the advice is given back to the president, there is no choice but to accept that advice. Now, what analysis we can make is that ultimately it is the prime minister and his council of minister is making the decision as far as the appointment of judges is concerned. This is very important amendment. So an inference can be made that council of ministers will prevail in such decisions, and that means it is a there is a possibility that there can be a political influence on the appointment of judges, and this is also one of the points of controversy. This could be controversial issue with regard to appointment of judges, considering the fact that in majority of the cases before the Supreme Court, the government is a party. Now, if you see the original jurisdiction of the Supreme Court has the original jurisdiction of trying the cases between the central government and the state government, or central government and state government in one side, and other state government is on the parties. So if there is a political influence in judges, you can imagine the consequences. There's a possibility of bias. The second factor, this is also one of the important factor of controversy, superseding of judges in appointment of Chief Justice of India in contravention of convention. Now, the convention which is followed by India as far as appointment of Chief Justice of India is concerned, we have a convention to appoint the senior most judge of the Supreme Court as Chief Justice of India. In 2 occasions, this convention was broken by the then government in violation. And to explain exhibit its supremacy. Now, in fact, there were three incidences. The earlier incident was in 1964, when Justice Gajendra Gadkar was appointed as Chief Justice of India, superseding the senior most justice Imam, but that was for medical reason. So they had a valid reason. But in these two cases, the reason was entirely different. Now we'll see what are those circumstances in which judges were superseded. In Keshwanand Bharati versus State of Kerala, 1973 Supreme Court judgment, in which Keshwanand Bharati challenged the 24th, 25th, and 29th Amendment. Along with, he also challenged the Land Reforms Act enacted by the Kerala state government. So Keshwaran Bharati case was a landmark decision that established the basic structure doctrine, which limits the power of the parliament to amend the constitution. If you remember the background of Shankari Prasad case, Sajjan Singh's case, the Supreme Court ruled that even fundamental rights can be amended. But Golaknath case reversed that judgment, saying that fundamental rights cannot be taken back through the amendment of the constitution. The rest of the provision can be amended. Fundamental rights cannot be taken away. To nullify this judgment, the government brought in the 24th Amendment. Now, this was challenged in Keshwanan Bharati. Amendments to the constitution, they were passed by the parliament. The amendment sought to limit the 29th Amendment. Some of the amendments were put under ninth schedule, which are not subject to judicial review. That was also challenged under this Keshwanan Bharati's case. Now, the judges who delivered the majority judgment were Chief Justice S.M. Sikri, G.M. Shelard, K.S. Hegde, N. Grover, P. Jagmohan Reddy, H.R. Khanna, A.K. Mukherjee. So these were the judges who ruled that though all the provisions can be amended, but basic structure cannot be changed, cannot be touched. Now, this is a ruling against the government. In the aftermath of the Keshwanan Bharati judgment, Justice Ajit Nath Ray superseded three senior most judges of the Chief Justice. That means three judges were superseded by the then government in total violation of the convention. A.N. Ray was appointed as Chief Justice of India. Justice Shelard, Justice Goa, and Justice Hegde were superseded, which resulted in their resignation. Now, this supersession was unprecedented in Indian legal history. Now, this was called as a black day also by these eminent people. Now, question raised was whether there is any rule of law or independence of judiciary, whether judiciary was under threat for the first time, because there was a debate that the minority judgment was given under the influence of the government, though majority just stated that the basic structure cannot be touched. Now, it is also alleged that it is a measure to control the judiciary by executive, where three senior most judges were superseded by a judge who gave judgment in favor of the government. Second case where the judge was superseded, ADM Jabalpur versus Shivkant Shukla, Supreme Court judgment of 1976. It is famously known as habeas corpus case. If you remember, the emergency was imposed on 25th of June 1975 on the advice of Prime Minister, the then Prime Minister, Mrs. Indira Gandhi, by the then President Fakhruddin Ali Ahmad. So under Article 352, national emergency was declared for internal disturbance. Many of the political opponents were detained under the provisions of MISA, which was known as a draconian law because of its harsh provisions. Article 14, Article 21, and Article 22 were suspended by the President using the provisions of Article 359, Clause 1. Article 19 was suspended using the provision of under Article 358. Writ remedies, which are available under Article 32 and Article 226, also were suspended. Now, at that time, many writs of habeas corpus were filed before many high courts and under 226. Such petitions were admitted by the high courts, despite Article 226 being suspended by a presidential order. High Court admitted such petitions. That was challenged by ADM Jabalpur before the Supreme Court. The petition was heard by a five-member constitution bench consisting of Justice A.N. Ray, Justice H.R. Khanna. Justice A.N. Ray was the Chief Justice of India then. Justice H.R. Khanna, Justice M.H. Beg, Justice Y.B. Chandrachud, Justice P.N. Bhagwati. So these were the bench which heard the case. The majority of judges ruled in favor of the government, saying that yes, the fundamental rights can be withdrawn um, during the imposition of emergency because the Constitution allows that. In a dissenting opinion by Justice H.R. Khanna in a minority judgment, Justice Khanna opined that the right to life and liberty are not conferred by the Constitution. Constitution only guarantees the availability, and these rights are available by birth as human right, and hence inviolable and cannot be suspended even during emergency. This is what is observed by the dissenting Justice Khanna, and he is well known for that judgment. And at that time, perhaps Justice Khanna was very much aware of the consequences of his dissenting judgment, because in his autobiography, uh, Neither Roses Nor Thorns, he has mentioned this incident to his sister, that he has given a judgment against the government, and there's a possibility that I may be deprived of elevation as Chief Justice of India, and that is exactly what happened after the judgment. He was superseded. And Justice M.H. Beg, who was junior to him, was appointed as Chief Justice of India. Now, this is the punishment for giving a judgment against the government. Now, the question arises if there is a rule of law in India at that time. Now, because of that superseding, Justice Khanna resigned. One of the judges who formed the majority opinion, now what the irony is that one of the judges who gave a majority opinion later gave a statement after retirement. I don't know why I went with the majority against my conscience, and my judgment was erroneous. In both the cases, now what does it mean? What analysis you can make? There was an influence of executive on the judgment as well. In both the cases, it was alleged that executive tried to influence the decision, and who gave a favorable decision was rewarded with the office and office of CJI, Chief Justice of India, and one who went against was punished. Third factor, uh, which leads to controversy. Three judges case and NGC Act. First judge's case is also known as S.P. Gupta versus Union of India. This is the Supreme Court judgment of 1981, heard by 7-judge bench, and decision was given 4:3. Now, during the tenure of Indira Gandhi as the Prime Minister, Law Minister P. Shiv Shankar issued a circular stating that at least 1/3 of the judges of a particular high court must be from outside state. out of total judges, at least one third of the High Court judges must be from other states outside the state. And there was a provision, the consent must be obtained from such judges whose names are proposed, whether they are willing to go outside the state. Now, what the original provision says that appointment of judges is consultation with the Chief Justice of India. Now, if this consent has to be taken by the concerned judge who is being transferred, then what is the value of consultation with the Chief Justice of India? That was challenged, and petition was filed in many high courts by practicing lawyers, and High Supreme Court withdrew such cases before it itself, Supreme Court, and it was heard by 7 judges bench. And ultimately, it was observed that the circular which was brought in by the law minister was unconstitutional. But executive and consultation is not binding on the president. Whatever consultation you make with the Chief Justice of India is not binding on the president. President can take his own decision as far as appointment of judges is concerned. Consultation is merely a formality. That is also agreed by the Supreme Court in the first judge's case. So, though it was debated by the legal luminaries that such a decision of the apex court is likely to have adverse effect on the independence of judiciary, though Supreme Court gave a judgment that executive has the primacy, though there is a consultation, executive has the primacy over appointment of judges. Now, this is debated by the legal luminaries that it will have an adverse effect on the independence of judiciary if the executive has the final say over the appointment of the judges. Now we'll consider the second judge's case, which is also known as Supreme Court Advocates on Record Association versus Union of India, Supreme Court judgment of year 1993. It was heard by a 9 judges bench. So during that period, what happened was there were many vacancies in the high courts, and no steps were being taken to fill those vacancies, since there was disagreement between the executive and the judiciary. Hence, this petition was filed because cases are pending before the high courts, and no steps were being taken to fill in the vacancies pending in the high courts, just because there was disagreement on the names by the executive and the judiciary. A petition argued that primacy should be given to the opinion of the chief CJI in case of disagreement. If there is a disagreement between the executive and the judiciary, primacy should be given to the CJI's opinion. Now, one more argument by the petition was that SP Gupta case ignored Article 50. Now, we have already discussed what is the provision in Article 50, which suggests that the executive should be separated from judiciary. That was not considered in SP Gupta case, and primacy was granted to executive. Court should interpret the meaning of consultation as concurrence. There was one more argument by the petitioners that the word consultation should be interpreted to mean concurrence. When you say concurrence, that means the agreement on a particular name which is proposed to be appointed as a judge. Executive should not be given final authority to appoint judges because it is most of the cases government is a party to the case. See, again, the question arises, executive should not be given the final authority to appoint judges because we have already seen the cases, majority of the cases before, which comes before the Supreme Court is where the government is a party. And if the government is a party to the case, if primacy is given to the executive, that means government, which has the final say in appointment of judges, then there's a likelihood of while pronouncing the judgment, there could be a bias by the judges who are appointed by the executive. Now, independence of judiciary is likely to put under the compromise. Now, what is the judgment in that case? Second judge's case overruled SP Gupta judgment. which also said that Chief Justice of India must given primacy in appointment. Then consultation means concurrence. That was the interpretation made by the Supreme Court. Consultation means concurrence, where both the parties must agree on a name, executive as well as the judiciary. Then they developed the system of collegium to mean CGM plus 2 senior most judges. The Supreme Court also felt that the power should not be given with one judge, that is Chief Justice of India. There should be a team or a committee, which is known as collegium, that is CJA plus two most senior judges of the Supreme Court. Now we'll consider the third judges transfer case. That is, it was not a petition, but it was a reference made by the then President of India, K.R. Narayanan. He wanted certain clarification on the second judge's case, which is this clarification can be made under Article 143, which gives power to the President to seek advice from the Supreme Court. So during the clarification, the number of collegium was enhanced to mean CJA plus 4 senior most judges. Earlier it was Chief Justice of India plus 2 senior most judges. Now in the third judge's case, it was enhanced to mean CJA plus 4 senior most judges. Now, it also said that the recommendation of the Chief Justice without following the norms will not be binding on the government. Now, after this pronouncement, there was a tug of war between the executive and judiciary over the primacy on appointment of transfer of judges and matter of controversy and prime concern. After this pronouncement, second judge's case as well as the third judge's case, where collegium, the doctrine or the concept of collegium was developed, then there was a tug of war between the judiciary and executive over primacy. Now, because of that, there were many times there's a delay when the collegium suggests some names, sends a list to the government. Actually, it sends the list to the law ministry, and which forwards after the detailed investigation on that name, that is forwarded to the Prime Minister. There is a delay because government does not want to accept the superiority of judiciary over executive. That is also part of controversy. Now we'll see National Judicial Appointment Commission Act of 2014, which is shortly known as NJAC Act, which was done through 99th Constitutional Amendment. The proposal to enact this act originated because of certain allegation by the government on the judiciary. There was certain allegation which was made by the executive of the government on the judiciary. I'll see what are the allegations. What they claim, what the government claimed, the appointment made by the collegium system is opaque. That means non-transparent. We do not know whether a particular judge is being appointed or elevated to the Supreme Court or appointed to the High Court. We do not know on what basis, what are the merits on which he is appointed. There's no transparency. Judges appoint these judges according to their vision will. There is no transparency. This was one of the main allegations by the government. Then secondly, it also alleged that nepotism is promoted by the collegium. That means they are near and dear ones, they are known ones, friends, relatives are appointed to the Supreme Court and the High Court, and transfer is also done on that basis. Now, this collegium system is famously compared to Gymkhana Club by the then Minister Arun Jaitley in a debate, saying that appointing judges is like members appointing members in a Gymkhana Club. That was the allegation made by the government also. Then third allegation was collegium takes too much time for recommending the names, and that is why the delay in appointment of judges. It also contended that there is a rivalry in the judiciary about the appointment. Therefore, government came up with the idea of appointment of judges through a commission. Now, this to do away with these shortcomings, government proposed to make a commission through enactment, that commission will recommend the names to the president. Hence, this act of NJSC Act, which is brought in through amendment to the Constitution, 99th Amendment to the Constitution. Now, we will see the composition of the commission. Uh, Chief Justice of India will be the chairman of the NJSC. Then two senior most judges of Supreme Court. Fourth member is law minister, and other two members are eminent persons. Now, there is a provision under the NJSC Act who will appoint these two eminent persons. As far as four members are concerned, there is no doubt, no question about that. Chief Justice of India, two senior most judges, law minister, four members of the NJSC Commission, and the two eminent person. Now, who will appoint these two eminent persons? That will be appointed by a committee consisting of Chief Justice of India, Prime Minister, and leader of opposition. Now, if you observe the composition of this committee, which appoints the eminent persons, there will be two political members, Prime Minister and leader of opposition. And one more provision. Now, these two eminent people will be appointed by the committee consisting of these three people. One is judicial member, two are political members. One more power is veto power. If any two members of the commission do not agree on a name, such name shall not be forwarded. That means important veto power to stop. That is given to any two members, so that any two members can be the eminent persons who are appointed by a committee having majority of political members. This was not agreeable to the judiciary. So after enactment of this act, Supreme Court on Advocates on Record Association filed a petition challenging the National Judicial Appointment Commission Act. The case was heard by 5-judge Constitution bench of the Supreme Court. On 16th October 2015, the Constitution bench of Supreme Court by 4:1 majority upheld the collegium system and struck down the NJAC as unconstitutional. So what was held by the Supreme Court? The collegium system was upheld by the judgment, and NJAC Act was considered as unconstitutional on the grounds of violating independence of judiciary, which is a part of basic structure of the Constitution. Independence of judiciary is a part of basic structure of the Constitution, and there's a interference of executive in the provisions of NJAC Act, and hence it is violative of independence of judiciary. That is what is observed by the Supreme Court while pronouncing the judgment and striking down NJAC Act as unconstitutional. So Justice J.S. Kihar, Madan Loku, Kurian Joseph, and Adarsh Kumar Goyal had declared the 99th Amendment and NJAC Act as unconstitutional, while single judge in a minority dissenting judgment, Justice Chalmeshwar, upheld the NJAC Act as constitutional. Now we'll see the pending cases before the Supreme Court. As of May 2024, there were about 82,308 pending cases in the Supreme Court of India. This is an increase of 1,607 cases from the previous month, which was the highest increase in the pendency so far in 2024. Now, if you consider the number of pending cases before the Supreme Court, there may be various factors which lead into such pending of cases. But one of the main reasons was the shortage of judges and delay in appointment. That is essential to be considered for today's discussion. One of the reasons of pending cases is shortage of judges and delay in appointment. Now we will see the cases pending before the High Court. As of September 2024, there were 58.59 lakh cases pending in high courts, including 42.64 lakh civil cases and 15.94 lakh criminal cases. Of these, nearly 2.45 lakh cases were pending for 20 to 30 years. See the time, 20 to 30 years. Now, again, the reason can be attributed to shortage of judges and delay in appointment. Now, what is important to note here that the 43rd Chief Justice of India, Justice T.S. Thakur, was in tears in a public platform. He was literally in tears in a public platform, and he tells PM Modi he must help reduce burden of the judiciary. What he contended during his speech, the government should not delay the appointment of judges when there is such a huge pendency of cases, said Justice T.S. Thakur. Further, we observed that the Law Commission recommended the increase in number of judges from 10 judges. Now, present number of judges is 10 judges for 10 lakh people, whereas the Law Commission has recommended that it must be increased to 50 judges for 10 lakh people. See the difference of 40 judges. The shortage is 40 judges for 10 lakh people. And he further observed, but nothing is moving because of government inaction. Now, again, the reason is the tug of war between executive and the judiciary. Why government is enacting? There's no action from the government. Well, concluding, so these are the whatever we have discussed now is the main reasons for controversy in appointment of judges to the higher judiciary, tug of war between the executive and the judiciary over the final say, who is superior in the appointment. Question over sincerity of collegium by the executive. Or executive always questions the sincerity of the collegium. What are the allegations we have already discussed? But in this regard, we would be interested in knowing what Justice D.Y. Chandrachud, the recently retired Chief Justice of India, said in a few months back before his retirement. Chief Justice of India, D.Y. Chandrachud, in a recent interview, defended the collegium system of judges, appointing judges to the higher judiciary, asserting that steps have been taken to ensure greater transparency. This was one of the allegations made by the government that there is no transparency. CJ Chandrachud assured that we are taking steps to improve, and there will be greater transparency in the future period. In an exclusive interview with the news agency PTI, the CJ said it is very easy to criticize the process, but every effort is being made to the collegium to ensure due process of consultation is followed before the appointment of judge. Now, I would like to conclude that let us have faith in the collegium system till a better option is made available to us, and justice administration system will continue to serve the people without any controversy, and people will continue to have faith in the judiciary. Thank you very much. Over to Shubhangi Panchal, madam.
Yes, sir. Thank you very much, sir. It was really a thought-provoking lecture where you have very nicely presented the chronological order also about the happenings that even the person maybe not knowing about this, but very systematically will and comprehensively will understand the issue of today's topic. It was a nice presentation with the PPT, sir. Thank you very much. And of course, yeah, of course. So the system of check and balance, which we were saying that yes, we do have check and balance wherein all the three organs of the state have control on each other. They are having a check on each other. But here is a question wherein we face a question that whether this check and balance is being abused now in these cases, wherein the government inaction is that is pressurizing the justice system also. The inadequacy of the judges, that is also one of the, of course, the cooperation and coordination among the organs, that will be a solution to it. Yes, sir. Thank you very much, sir. if any questions are there from the audience, any discussion, I would like to really, students can raise their hand and we can have a good discussion on it.
Very nice, Shetty sir.
Thank you, sir. Thank you. It's your under your guidance and mentoring, sir.
I'm traveling. I'm in your area. I'm traveling from Dharwad to Belgaum.
Okay, sir. Thank you very much. Despite your busy schedule and your traveling, you attended my lecture. Thank you very much, sir.
Okay.
Thank you, sir, for making it a point to attend. Your presence itself is very much supporting and inspiring for us, sir. Thank you, sir. Thank you for the response. Any discussions from any side? Or any reactions also are very much welcome from the teachers or from the students. Of course, sir, you have concluded nicely that that is what we have to believe in the system and we have to hope for the best, that without any controversy, we'll have the system very well going and to serve the people.
Yes.
Yeah. I think then we should conclude with the lecture, sir. Once again, thank you for all the students and all the teachers.
I would like to express my gratitude
for
giving me this opportunity. I would like to express my gratitude to respected Bajpai sir, who has initiated this under faculty development program to have a lecture series, and to the principal madam, respected principal madam, Dr. P.P. Nathani, as well as coordinator Shubhangi Panchal madam, giving me an opportunity out of turn, I would say. I think out of turn, because according to the schedule, my name comes after 4 or 5 lectures. I was given the opportunity first. Thank you very much, Shubhangi Panchal madam. Thank you. And thank you everyone, every one of you who have attended this lecture, my esteemed colleagues from the teaching faculty, as well as the students. Thank you very much.
Yes, on behalf of the students and the teachers and even the college, we thank you for a very thoughtful lecture of this particular. So the reactions are coming from the students. So those are evident. Thank you very much, sir.
Thank you, ma'am.
Thank you. So with the permission, may I end with this particular lecture? Thank you, one and all.
Yes, ma'am.